All right, everybody, if you can please take your seats. The main event, the cage match, is about to begin. We decided this year, instead of our traditional lunchtime keynote address, to have a lunchtime keynote debate. This is going to be an actual debate, Oxford rules. Peter will explain more all about it. Dealing with one of the hottest issues on the table in the industries these days, the regulation or not of over-the-top services. And so to moderate the debate, lay down the law, and introduce the debaters, I'd like to introduce you to our good friend Peter Grant, counsel at McCarthy Tétrault, longtime guru in the broadcasting communications regulatory area, and also a longtime member of the planning committee of this program and the founder of its sister program, the Communications Law Symposium, that runs every other year as well. We're very, very happy to have Peter with us today, and I will turn things over to him to explain what's about to happen. Enjoy.
Thank you. Thank you, everyone. Good afternoon. For your entertainment pleasure, we are now going to have a debate, and the resolution is resolved that over-the-top OTT services are not, should not be regulated by the CRTC under the Broadcasting Act. And arguing for the resolution will be Timothy Denton. Tim is a former CRTC commissioner from 2008 to 2013, and he is currently with the Windermere Group. Arguing against the resolution will be Jay Thompson. Jay is Vice President, Broadcasting Policy and Regulatory Affairs of the Canadian Media Production Association. Now let me outline the process we have agreed to follow for the debate. I will first ask everyone to vote on the resolution without having heard from our two debaters. And this will give us a baseline for comparison. And then we will have the actual debate. First, we will hear from Tim Denton, who will have 10 minutes to argue in favor of the resolution. He will be followed by Jay, who will have 10 minutes to argue against the resolution. Then we will give Tim Denton 5 minutes for rebuttal. And finally, Jay Thompson gets 5 minutes for final rebuttal. So both of them in the end will have the same amount of time to persuade you one way or the other. And to make sure it's fair, I will make sure that everyone observes the time limits. And we have a little counter here with some green and red lights, so I hope that'll do the trick. And after the debate concludes, I will then ask for a second vote on the resolution. We will then compare the two votes to determine who won the debate. The winner will be the one who moved votes one way or the other. So those are the rules. And to begin with, I should just tell you a bit about how to vote. All of you, I hope, will have received... I hope everyone here has received one of these items. If anybody has not, could you raise your hand? Because they will now hand you a couple of extras, so everybody has one. And for those who are participating by webcast, in a minute we will be putting onto your screen a pop-up which allows you to go into it, and then you will be asked a choice to vote yes or no. Okay? Now, does everybody now have one of these voting things? We need one up here. Just take a second, ma'am. Now, remember the resolution. It's resolved that over-the-top services should not be regulated by the CRTC under the Broadcasting Act. That's the resolution. And in a minute, I will tell you to do your vote. Now, those who are in favor, in other words, agreeing with the resolution, will press 1 on their thing when I tell you to do so. Those who are against it will press 2. Everybody understand the rules? Okay, I think we've got everybody organized. Now, let's see here. Oops, that's not it. Resolved. Okay, you see on the screen there, I guess, what the resolution is. So I'll now ask everybody to press 1 if you agree and 2 if you disagree. Give another 5 seconds for you to put in your number. Okay. I guess we're waiting for that green thing to change from polling open to polling closed. Is that correct? It's closed? Sorry. Okay. Okay, I guess we can proceed. So let's start the debate. First, let's hear from Tim Denton. Tim, you have exactly 10 minutes to argue in favor of the resolution.
Hello, everybody. Peter Grant existence reminds me of the fact that when you start your career, you should be nice to everybody right from the beginning. Peter and I first met when we started back in 1976, or was it 1776, at the CRTC. And Jay has been held the same job as I held as the Council of the Canadian Association of Internet Providers. So we've all been around this issue several times. And it is somewhat ironic. I mean, I think this debate is the equivalent of, how should I put it, perhaps Alexander Hamilton and Aaron Burr having a debate about the creation of the U.S. bank or not, judged by or moderated by Thomas Jefferson. Possibly a bit like having Galileo versus the Inquisition moderated by the Pope. But you've been very kind so far and haven't eviscerated me yet. So the question for us all is the question whether the internet should be regulated for over-the-top services under the Broadcasting Act. And my, you know, the joke that in a sense everything past a certain age in life is either immoral, impossible, illegal, or fattening. We have agreed to keep the legality of the question out of this discussion, and so we're merely discussing whether it's impossible, immoral, or fattening. And over the top, I want to clarify that. I think over the top is over the top of what? And over the top, for me, and I think for everyone who understands it, signifies the passage of signals across the TCP/IP, the Internet Protocol Control Layer, to over the top of physical apparatus. And so what's happening as we observe the world changing is that broadcasting is becoming an application like the World Wide Web or like Uber or like any other B2B or any other kinds of application found on your devices to receive signals. And a particular a form of signal, broadcast television, which used to have its own special distribution system, is now brought into it's basically brought into the general platform of distribution of signals, which is the internet. And that's what's going on. And so the question then is whether the form of regulation that applied when television was television and not brought to you as an application over the internet, whether this form of regulation should pass forward in time to regulate what is now an application. So I will say, quite frankly, that what this issue is about is freedom. It's not about regulating the internet, it's about regulating your speech. The opposition will, I think, of necessity have to say that it is full motion video. It's therefore a licensable activity. And if you're going to engage in a licensable activity under the Broadcasting Act, you should be regulated under the Broadcasting Act. For me, to speak, that is to say, to convey information across the internet in full motion video, is a form of speech. And for me, the issue is, and I invite you to consider, that the fundamental issue is whether we're going to communicate across the internet by means of full motion video, whether this will take place with permission of the state, and therefore by license, and therefore by penalties if we don't obey the terms of the license, or whether we're just going to do it as we communicate by phone, by writing, by email, or by any other system of transmission predicated on the printing regime. So they've got to say basically that the system of regulation they propose will be carefully crafted to gather the 0.000001% of websites that actually matter, that it won't really affect your rights to upload video, and it won't cost too much. You won't notice it. Don't worry. You know, all's well. Canadian broadcasting will survive. Well, the problem with that is that the Canadian broadcasting system is just so 20th century. It is co-emergent with the emergence of radio broadcasting. And by 1930s, radio broadcasting had evolved, the system of radio broadcasting had evolved such that systems were propagating in space without artificial guide, meaning there was radio, it went out, it was very loud and electronically noisy, and that what was necessary to control this was the authoritative assignment of spectrum to uses by the state by means of licenses. So the broadcasting regime was layered over a certain technical idea of how communications should occur and was predicated on the scarcity of bandwidth. By the way, the same scarcity of bandwidth which is itself created by the system of state licensing of bandwidth. It was predicated on locality because signals originated somewhere, and range because of radiated power. So voices were few, and the opportunity for exercising control of what people heard was real because the speakers were few. Broadcasting was layered on top of radio licensing on the same assumptions, and no change to either regime has occurred by reasons of advances in computer power. Now, I use the term speech in the sense of encompassing print, drama, talking, or whether or not augmented by a technical system, whatever. Speech through a printing press is a 15th century augmentation of the written word. Radio is a 20th century augmentation of speech, and television, in the main, is an augmentation of drama. Now, when I say speech by permission of the state, I invite you to actually read the Broadcasting Act. Remember, we're not talking about whether the internet can be regulated. It's regulated in 1,000 different ways. So is the publishing industry. We're talking about speaking by permission of the state in the form of a license or by exemption from licensing, which has been admitted already today by others, is just another form of regulation. If you speak without a license across this technical mechanism, you're subject to, in the case of an individual, to a fine not exceeding $20,000 for each day that the offense continues, or in the case of a corporation, to a fine not exceeding $200,000 for each day the offense continues. These are important handles by which we keep a grip on what is thought to be a special form of speech. The older form of speech, of course, is printing. And after a few revolutions in the English-speaking world, we didn't need a state license to operate a printing press. And the form of liability is that you're liable after what you have written, not before. So you're not taking your speech, your writing, to the office of the, I don't know, the Holy Inquisition or the Royal Censor to have your plays or your speech or your written blogs or whatever subject to a pre-existing approval of the state. The internet belongs to that older system of law. You don't need permission to speak. The argument, how many?
About 1 minute and 42 seconds.
The argument, therefore, is that who says full motion video says broadcasting and who says broadcasting says licensing. And exemption orders are just another way of attaching conditions to that. So what's it going to be? Is it going to be licensing under the Broadcasting Act or no licensing under the old regime of freedom? The opposition will say a microscopic number of sites will be regulated. We're only collecting a teensy-weensy little tax to soften the blow of the internet on broadcasting, and it won't hurt at all. As we all know, that's not going to work. Shortly. When the business model fails, go to the government and get some help. And basically, broadcasting is a declining industry in an obsolescent technological form. It's having its guts eaten out by modern forms of communication. This will not and cannot stop. And attempting to go to the Broadcasting Act and government for saving a failing business model will fail. And I hope you will make it so. Thank you.
Thank you very much, Tim. And now I turn to Jay Thompson, who has exactly 10 minutes to argue against the resolution. Here we go. Let's see here, getting my timing going. How do I get it started? Great.
Starts when I start. Clock start. Well, I agree that this debate is not about regulating the internet, nor this debate about freedom of speech, and neither is it about preventing the young computer whiz in her basement from inventing the next great app. Those topics are pretty sexy, but they're a lot sexier than the topic that we are debating here today. And I would suggest that they're a lot that even my learned colleague here, at least his passion for his arguments, is a lot sexier than the debate that we're having here today, particularly given that tie he's wearing. I'm sorry to say that this debate is about this boring subject of statutory interpretation. It is a legal debate. And it's also about big media companies, companies called Bell and Shaw and Rogers, companies which are, of course, quite thankful that Tim is here defending their interests. The resolution is, should the CRTC regulate OTT? This is not, nor should it be, a debate about the relevance of the Broadcasting Act today, or of the Commission, or about the role of regulation generally. OTT is, of course, an acronym for over the top, but over the top, as we know, is capable of many meanings depending on the context. In fact, it could be applied to this debate, as in, should the CRTC regulate Tim's arguments? Because in my mind, they're a little OTT. In this context, though, OTT is generally defined as the delivery of content over the internet without the involvement of a BDU, or in the US, an MSO. So it's the delivery of content that in the past would have only been available through a BDU. And that narrows the scope of this debate substantially right off the top. Nevertheless, to avoid confusion, I'm going to use real-life examples, namely the Rogers Shaw service Show Me and the Bell-owned OTT service Crave TV. And in this way, I submit that the question here becomes more clear and more real, as in, should the CRTC regulate Show Me and Crave TV? And I sum up my position in just 4 words: can, must, should, can. That's 3 words, but okay. So I agree that, or at least I differ from Tim in respect of, before we consider whether the CRTC should regulate Show Me and Crave, I think we do need to determine whether it can do so. And I submit that not only it can, but it must. And because it must, the question becomes not should the Commission regulate, but how should it regulate? And our starting point, of course, is the Broadcasting Act. So for somebody is broadcasting in this country, they come under the Federal Broadcasting Act. And where we know that Show Me and Crave, whatever it is that they're doing it in this country. So are they broadcasting? And the 4-point test is, are they transmitting programs by means of telecommunication for reception by the public? So here's my Coles Notes version of addressing that test. First, Show Me and Crave offer TV shows. TV shows meet the Act's definition of programs. Second, they use the internet, and I think even Tim would agree that the internet is another means of communication. Third, they base their business models on making their programming receivable by the public. So that leaves us with the question of whether they transmit. So I'll get into a bit of law here. In SOCAN against CAPE, the Supreme Court equated transmission with communication, and it confirmed that the person who posts the content communicates or transmits it. So in this context, that would be Show Me and Crave. Now, the SOCAN case was obviously about copyright, not broadcasting, but the Supreme Court held in the Fee for Carriage reference case that the two acts, the Copyright Act and the Broadcasting Act, are part of the same interconnected statutory regime. And in such cases, items in common should be treated in harmony. So, because Show Me and Crave transmit in the copyright context, I submit they transmit in the broadcasting context as well, and that meets our 4-point broadcasting test. So they're subject to the Broadcasting Act and they're subject to the Commission's jurisdiction as a result. And the Supreme Court, I believe, supports this conclusion because in the ISP reference case, which held that ISPs do not broadcast, it's because they did not select, originate, and package content, but that's exactly what Show Me and Crave do. So if the CRTC has broadcasting jurisdiction over an undertaking, then it must exercise that jurisdiction. It can't leave those undertakings alone. It has to do something. And with Show Me and Crave, as with other broadcasting undertakings, the Commission has two choices. It can license them or it can exempt them. And it can apply some form of regulation or no form of regulation, but it has to do one or the other. So that brings us back to the question of whether the Commission should regulate Show Me and Crave. And I again recast this question as, how should it regulate them? And I do this because the objective to be achieved should dictate the form of regulation to be applied. And I submit that the objective in this case, the case of Show Me and Crave, is the one the Commission itself identified back in 2011 when establishing its group licensing framework, and then reaffirmed in its recent Let's Talk TV decisions, which is to stabilize financial contributions to the creation of Canadian programming in a changing broadcasting environment. Why is this necessary? Again, as the Commission stated in Let's Talk TV decisions, financial support is required to ensure the necessary resources are available for Canadians to create a diversity of Canadian programming. Now, the Commission forecasts that over the next several years, Canadians will continue to migrate from scheduled and packaged programming services to on-demand programs. Reed Hastings, who heads up a Show Me Crave equivalent you may have heard of, puts it more bluntly. With his stock trading at over $500 a share, he recently told happy shareholders that clearly Internet TV will ultimately replace traditional TV. In light of these kind of projections, the Commission has acknowledged that it must devise a regulatory framework that is responsive to the ways in which content can and will be delivered. I agree. Currently, traditional linear broadcasters account for 2/3 of all financial support for Canadian programming. I'd venture to say that Show Me and Crave, on the other hand, account for almost no financial support. This is because Show Me and Crave's online services are subject to the Commission's Digital Media Exemption Order, which includes no regulatory obligation to make any financial contribution to Canadian programming. It's also because, while to their credit, Show Me and Crave do offer some Canadian shows, although I didn't see many highlighted in the Show Me clip. They get those shows apparently for little or no extra charge because they've already licensed them for their affiliated linear services or co-licensing them with existing Canadian services. So here's the picture. It's agreed that Canadian television programming needs financing to have a future. It's agreed that Show Me and Crave will ultimately replace those linear broadcasters. But who will replace the financing? It has to be broadcasting services like Show Me and Crave. Unless ISPs start contributing, which would be wonderful, but unless they do, there's nobody else. So here's my final kick at the can. It would not be difficult for the Commission to impose a spending obligation on Show Me and Crave. It could simply add that obligation as a condition of eligibility for the Digital Media Exemption Order. A more elegant and targeted way would be for the Commission to revise its definition of broadcasting revenues so as to include the revenues that licensees like Rogers, Shaw, and Bell generate online. In fact, in the Let's Talk TV proceeding, the Commission actually tabled that very proposal. Unfortunately, the Commission ended up abandoning it, and its rationale, questionable in my view, was the spending obligation could impact on innovation. That rationale seems to ignore the fact that Canadian broadcasters have constantly been innovating throughout the history of the Canadian broadcasting system. And they have been doing so, in my view, not despite their regulatory obligations to support Canadian programming, but because of them. Fortunately, the Commission seemed to indicate that regulating Show Me and Crave is not a question of if, but of when. That's because it stated that it would not require contributions from those OTT services at this time. I take from this statement that the Commission confirmed it can regulate Show Me and Crave's OTT services. The remaining task, therefore, is to convince the Commission that it should do so. And for the future of Canadian programming, it must do so sooner rather than later. No doubt I've convinced Tim that he can and should help me convince the Commission in this regard. Can, must, should, can. It's as simple and as important as that.
Let's see here. I'm trying to adjust the timer here for a 5-minute measure instead of, let's see how this works. Thank God for technology experts here. Perfect.
4:54, give me 5, will you?
Yep.
Okay, that's my 5. That's my 5. All right.
Go for it.
All right. Hi, everybody. Welcome back to this reality show. This is not a question of statutory interpretation, and my original understanding of this debate that we were not going to be debating law. But let me tell you this one. If you think you're going to get away with this, the Broadcasting Act and the Commission's jurisdiction over the Internet will be challenged. And point-to-point communications, I don't care whether anyone in this room thinks otherwise, will not be found to be broadcasting. That's all I want to say about the legal issue. There's going to be expletive-deleted war on this, and wait till you find it when you go the wrong way. I was sitting around rather bored in a commission hearing one day, and we made a decision on usage-based billing. Jesus, did we ever get that one wrong? An obscure issue of telecommunications pricing had the public up in arms. And we were roundly beaten about the head intellectually for failing to understand that charging for the internet this way, in a time of declining Moore's Law, declining cost per bit and keeping the price stable, was not a good way to charge. If you think that UBB decision was just a minor kerfuffle, wait till you try to start regulating people's use of the internet by uploading video. The argument is not about saving the Canadian broadcasting industry. That is a useful and important discussion. How are we going to finance Canadian broadcasting in an era of the internet? Now, the old way of doing it was to hell with the goddamn technology, let policy be imposed. Well, at a certain point in time, the technology is sufficiently superior to any attempt to regulate it by the old means. You've got to start thinking anew as to how you're going to do it. And assumptions based on licensing, restriction, limitation in a world of absolute abundance of video and every other kind of communication is just not going to work. And I'm sorry to address one's attentions to reality instead of the law, but we need to get a grip here. If you think that this proposal to save the Canadian broadcasting industry, a cosseted and regulated little creature of Canadian policy, somewhere between Montreal, Toronto, and Vancouver, and Ottawa, is going to be saved by just this tiny little extension of regulation over Show Me. Ooh, just a little one, just a little bite. No siree. it's not going to happen. There will be a political earthquake. You may have noticed, I'm sorry to be so rude, you may have noticed that there has been a conservative government in this country for some time now, which is apparently going to continue, I think. In any case, this government has not, I got the time, Peter, this government has not been faithful to the extension of CRTC regulation, and it's not going to happen this time either. But the more important thing to keep a grip on is that everybody's freedom to communicate through the internet by means of video programming, I have 1 minute 36, by means of video programming is not and should not be a regulated, licensable, permission of the state required thing to do. Uploading your niece's birthday party to the internet is, under the definitions proposed and accepted, a licensable activity. Now, in the time we have spoken, there's been 22, in the time since the 2009 decision and the creation of the internet, I think there were 22 doublings to the power capacity of computers. In the 6 years since then, there have been 3 more at least, maybe 4. And these doublings keep on amounting to some revolution in the affairs of people that must finally, even by lawyers, be considered as relevant to what people can and should do with their freedom to communicate. And when you start saying to people that your freedom to communicate by video, by you sending a video across the internet, is subject to the licensing or exemption powers of the CRTC, to be a good little boy or girl and communicate in exactly the way we think you ought to, it's not going to wash. Now, I have left out the legal argument. In another debate, I would have been happy to engage it. But at a certain point in time, we need to consider what this resolution really means. We are not going to save the Canadian broadcasting industry by this incremental fiddling with definitions. And we're not going to save it by tiny little taxes that won't hurt a bit. We've got to think the saving of the Canadian broadcasting industry independently of regulation of video across the internet.
Thank you, Tim. So our final rebuttal will come from Jay. Jay, you have exactly 5 minutes. Let's see here. There we go. Oops.
So I guess I got him a little riled. So I want to address some of the points that Tim make. What kind of speech are we talking about here? What kind of speech does Tim really want to protect? It's $1 million per episode professionally produced programming, produced by and distributed by a very limited number of billion-dollar companies. Companies with names like Rogers, Shaw and Bell, as well as Amazon, CBS, HBO, Sony, Fox, and yes, Netflix with a $34 billion market cap. This is not a debate about technology. The Broadcasting Act is technology neutral. It is not limited to old traditional forms of broadcasting. It applies to content delivery using any means of telecommunications. Spectrum scarcity is irrelevant. While the form of regulation applied in days of old may have been designed to address the challenges of spectrum limitations, it's not the rationale for regulation. The rationale is to achieve the objectives in the Broadcasting Act. And nowhere in Section 3 is there any mention of spectrum scarcity. In fact, there's no mention anywhere in the Act of spectrum scarcity. So how would Show Me and Crave be any different if they'd been subject to a spending obligation right from the start? They might simply be more expensive. But would they have not launched? I doubt it. And we haven't debated Netflix here, which is a good thing, but let's look at them anyway. How would it have been different if they had been subject to a spending obligation from the start? Would they have refused to enter Canada? Well, maybe at first. But what if other countries had then done the same thing as us? Would Netflix have limited its service to the US? Again, I doubt it. It would have forged ahead and accepted those obligations as a cost of doing business. Over the last 3 years, Netflix spent $11 billion on content. I think there's room in there for some contribution to Canadian programming. Permission. We're talking about big content players here who have never operated legally without permission. They need the permission of rights holders. They need the permission from tax authorities. They need to obey applicable laws, whether they relate to things like false advertising, gambling, or child pornography. In certain jurisdictions, they must abide by rules relating to making their services accessible to the disabled. As a default, the Act requires licensing, and we have to dance here with the one who brung us. But ultimately, the starting point is, do we care whether Canadians are able to create professionally high-quality TV programming going forward? Do we care whether Canadians will get an opportunity to access and view such programs? Do we care that as the global broadcasting content communications industry evolves, whether it will offer opportunities to Canadians to contribute at a high level and access that content as well? Do we care that alongside the predominantly American choices that will dominate future content, as it does now, there'll be at least a spot for Canadians in that future? Tim obviously doesn't care, and that's fine. No more Christmas cards from me, but that's fine. But I don't think most Canadians share his view.
Well, thank you very much to both of our debaters. And I wonder if you could join me in thanking our two debaters. Okay. Great. Now it's time for the second vote on the resolution. And I'd like to open the possibility now. So could you please vote now? Remember, it's resolved that over-the-top services should not be regulated. So if you agree with that resolution, press 1A, and if you don't, press 2B. And those who are in the webcast, I hope that a pop-up will have shown on your screen, and you'll be given an opportunity to vote either 1 for yes or 2 for no. I'll give 10 seconds for all of these responses to be put in. 5 more seconds. Okay, that'll be the end of the vote.
Who brings the numbers forward? Does someone back there bring the numbers forward for us?
Yeah. So I think they're going to be showing on the screen, if I'm not.
Yeah, the pre-debate first, then,
Yes.
then the later.
Yeah, let's find out what the percentage on the first vote was first. If you could give us that. No.
No.
No. No.
No.
Easy to measure the impact. No great math.
Is that the original measure? 50-50?
I didn't vote. Wait, I didn't vote.
Okay, so is this the first? Oh, this is the first one. Okay. So, am I right? Can I be informed that the first vote was 50-50? Literally right on the money. Isn't that hilarious? But the second vote, as you can see, the percentage in the favor of the resolution dropped a bit. So I'll therefore declare the winner of the debate to be Jay Thompson. So congratulations, Jay. However, I would be remiss if I didn't thank our other debater. He did a valiant job and also deserves our praise. Thanks very much. Thank you, everybody.